It's your first court hearing in the juvenile CPS court, the Arraignment and Detention hearing. Come with me and let me explain how you might be able to fix this horror story. After your children have been taken by the social worker, the law requires that you be given the opportunity to go to court and challenge the social worker. This can be a long process. The social worker has to notify you within 48 hours of you losing your children that you have a court date. Some counties in California use the 72-hour rule, which some appellate courts have upheld, despite what the law says. If you are taken to court after this time, request that your attorney make a motion to dismiss the case for failure to have the hearing within the required 48-hour rule or the 72-hour rule. At your first hearing, if you have not hired a private attorney to represent you, California law requires that a court-appointed attorney be given to you to represent you in this matter. At this hearing, you and your attorney will be given the discovery in the case. This usually includes the allegations filed against you, which is called the 300 petition, the supporting documentation, including the application for petition, and the detention report. Not all children are recommended to be removed from parents, but in cases where this is recommended by the social worker, it is important that you and your attorney receive the discovery documents and try to craft arguments as to why the children should be returned to your custody. The difficult thing at this hearing, and only at this hearing, is that the judge must accept the allegations by the social worker as true. After this, the social worker must prove the case against you. If you are in disagreement with the judge's ruling, California law allows you to have a contested detention hearing. At this rehearing, you may cross-examine the social worker live and on the stand, and in some cases, the judge may permit you to present some evidence on your behalf. The most important thing for you to know at this hearing is that you have a right to a speedy trial. If the children are removed from your custody, your trial may be within 15 judicial days from the children being removed. Your trial may be within 30 days if the children are not removed from both parents. The reason that is important is that a lot of juvenile courts are extremely busy, and your trial may be scheduled 2 or 3 times past the 15 or 30-day rule. Now, and in some cases, this may be beneficial to the parents, sometimes not. There are all sorts of things you need to know and should consider when scheduling your next date after the initial hearing. So why do I share this information with you? I share this information so that you will know what can be done when things are going wrong in the courtroom. I realize you're seeing this because you have questions or concerns about your matter. If your matter happened here in California and you're thinking about your situation, I invite you to pick up the phone and call me. You know, I answer questions like this almost every single day, and I'd love to talk to you. You can reach me at 888-888-6582 or by email at v@vwdlaw.com. We will file the right legal documents and briefs to give you the best chance at getting your children back. That's it for this video. Have a great day.